Good morning, everyone. Welcome back to Senate Judiciary. We have several bills for our consideration this morning. Last day to get them out of committee is how this works. We've got colleagues from the other side who have sponsored legislation, so we set up 2 special meeting times to try to get through these, to try to get the opportunity for our fellow members of the House to get their bills in front of us. I want to back up and thank the Vice Chairman, Senator Cooper. Thank you for grabbing a hold of things last week when I had to be gone and shepherding things through and getting us all lined up for today. So thank you, Senator Cooper. Just a couple more notes of interest. The House Bill 125 is the 4th bill for our consideration. A lot of interest in that one. A lot of you are here, I think, on House Bill 125. We will pass a sheet around. I would ask if you would please fill that out. Let us know if you're testifying pro or con. We're going to try to be as fair and judicious as we can today. I do not expect to be able to get through that bill today. We'll have to carry it over till this evening. That's why we scheduled another special meeting for tonight. So I would think that with these 3 bills that we've got to get through, and then we get to 125, we'll do the best we can. We'll get started on testimony if time allows, and if not, we'll carry over to tonight. So let's get started with House Bill 134, Property Tax Deferral Program Amendments. And good morning, Representative. You know, just for the record, if this would have gone to the Corporations Committee, you still would have seen Senator Case and me. You know, I'm on his committee over there. So.
Well, good morning. Are you ready to start, sir?
Yes.
Mr. Chairman?
Do you have a green light?
I do have a green light.
I'll ask you, Representative, pull that good and close.
Okay.
Take it away, Representative Lawley, and talk to us about House Bill 134.
Thank you. Good morning, Chairman Landon, Senate Judiciary. I'm happy to present House Bill 134. It's a bill I actually brought last session, and it died in Senate revenue. It passed the House, but it is a bill that amends a current program that we have for property tax deferment that's been in existence for a number of years. But that bill, or that statute, requires each county to stand up the program. And so far, Teton County has the program. I think for a period of time, Sheridan County had it a number of years ago, and no one really used the program, so they took it away. But for counties in my district, it is very difficult to stand up this program, the personnel, the ability to withstand the deferment itself. And so basically what House Bill 134 does is it pulls the program up into the Department of Revenue and has them run the program. They would then take the applications for the deferment. They would then make sure their people are qualified under the statute for the deferment, and then they would approve the deferment and then pay the counties the amount of money for the deferment. So the counties are made whole, and it is the Department of Revenue on behalf of the state that would take the tax lien for the deferment, because again, a deferment is an agreement to delay the payment of tax. So no tax is lost, but it is deferred. And I'll just say this, that I watched a good bit of the Revenue Committee's interim hearing, and of course we had our own discussion in the House about this current property tax situation. And often I would hear folks talk about, and even heard people testify to the fact that they or a neighbor or friend that they knew were older folks that were in difficult financial situation with the rise of property taxes, that they were in a situation of possibly having to sell their home. And in many ways, this is actually the target group for what I want to do, and what even this in the original statute I think was targeting. And so again, after hearing all that testimony, I was even more deliberately wanting to come in and bring this bill again, because I think it was very much misunderstood by some. They didn't understand we already had the program. We're simply lifting it up out of the counties, or who it would help. And in what ways in terms of individuals would it help, but also how it helps the smaller counties to have it run by the Department of Revenue. So that's kind of the basic background. We're amending that deferral statute. House Revenue did make some amendments, and I'll talk about those in a minute, but they were made primarily because of testimony they received from the Teton County assessor about the program that she's running and how she felt it would be used more if, for example, the original statute required that you could only defer 50% a year of your property tax for that year. And she felt that if that was up to 100, you could defer up to 100% of your property tax for that year, that more people would use it. There was also testimony taken in the House Revenue to the fact that they felt that first, there were some folks that had just a small amount to pay on a mortgage, and that giving the department discretion in those cases to take a second lien position rather than the priority lien normally that a tax lien would have. And so those were the two amendments that were made in Revenue to allow 100% a year of the tax to be deferred. The statute also contains another provision that is a protection for the state, is that if once you reach 50% of the fair market value of the property in deferments, you can't defer anymore. So that's in the statute and stayed the same, but they just changed the amount annually that you could defer, and then provided this discretion within the department. And I think you'll hear from them this morning that they are comfortable with having that and understand the intent of that. So were already some pathways that you would get to work to qualify for this deferment. And the first one was had to do with sort of a means testing, income level that is already in the statute. And that income level in today's terms would be $75,000 per family of four. So that was one avenue, and these are all independent. The other one was being over 62 years old. Another independent pathway to get a deferment is that you have Social Security disability, and that, again, as determined by the Social Security Administration, you have that disability rating, and another pathway was that you would live in the home, had lived there at least 10 years. And then I did add in the bill another pathway, another independent pathway, and that is for disabled veterans as determined by the VA and with what's called a compensatory disability. So that I did add that additional pathway. And I will just say this, and I will be happy to go through the bill. I know you have a lot to do today. There's some questions specifically, but what this does is gives freedom to a certain group of people to consider this option. This option isn't for everybody. It's not represented as being something that will help every taxpayer. But, it doesn't need to help everybody, in my view. We just need to see that those that are helped are somebody that we care about and want to take care of in Wyoming. It's just an option that may help some. And I believe that that's what we should be offering as legislatures, different options for different taxpayers. And we do that in many different ways through some of the bills that we are seeing this session and we saw last session. So with that, again, I'll stand for questions, or I'll be happy to, again, go through the bill. Chairman Landon, if you would prefer me to go through the bill specifically, I can do that, but I know you guys have a lot on your plate today.
Well, Representative Lawley, well done. Thank you for that. That catches us up pretty well as to what the other chamber did to the bill, helped it, and et cetera. So questions, committee. Any questions for Representative? Senator Schuler.
Thank you, Mr. Chairman. I only had one question. When I looked over the bill, and I think it's on page 9. It was the appropriation of $200,000 from the general fund. Do you think that, knowing what you know about how much the program has been used, do you think that's going to be enough to cover what could happen down the road?
Representative, go ahead.
Thank you, Senator Schuler. I do believe it's enough. There is still a lot we don't know, and if we needed to come back in a supplemental budget request and add more, if it really took off in some counties, I think there will be variance in counties in how much they use it, but I feel confident that this is a good place to start.
Okay, further questions of the sponsor? Thank you, Representative. If you can stick around, Senator Furphy's got one.
Thank you, Mr. Chairman. I just have a question about what we're allowing the department to do is to make decisions. For example, on page 4, line 9, provided that the department itself may at their discretion defer priority and take a second lien position on the property. That's interesting, and it also, up above on that page, it makes it clear that the deferment of the taxes will initially with priority over any other lien. Now, I know we're trying to correct that, but still, the department may place a second lien on your property. And also, any deferred taxes, as it says, is payable on death of the owner. So that's a big concern to a lot of people about that. And, Mr. Chairman, if I can continue.
Please do. I know you're getting to a question
Yeah.
here pretty quick.
On page 5, what we've changed in this amendment, county commissioners previously could assess a rate of 4%. Now, it's going down to the department may put a yield on it of 10-year treasury, which is about 5%, and an additional 1.5%. So this is 6.5% in current market versus what we had at 4% before. So that seems a concern, Mr. Chairman, and I'll ask the representative to respond to those issues. Thank you.
Representative, go ahead.
Thank you, Mr. Chairman. Senator Furphy, I will try to remember all those, but the amendments made by this House Revenue Committee included not only the 100% of a tax year, but adding this provision, giving discretion to the department. And here, it's not really a second lien. That is a little bit of a misunderstanding of the language. A tax lien, just under lien law, always has a preference legally. It just takes a preferential order in terms of which liens are satisfied first, which are second, et cetera. So the thinking here, and it was based on some testimony they heard in revenue, that there are some people that are very close to paying off their mortgage, but they really need this kind of relief. They might take advantage of it, but they still have a small amount to pay on the mortgage. And the discretion being given here is for the department to look at all those factors. They don't have to take a second lien position, but they could consider in those circumstances, if they felt that it was, again, didn't put the state at any jeopardy of taking a lien position that might not be paid, they would take the second position and let that small amount of the mortgage remain in the first position. So under the way the lien law would work. So it just simply gives the department the discretion, and it says may. It does not say they shall do that. It says they may do that. And again, there were those that spoke that felt that that would be very helpful for this kind of target audience that we're aiming at giving this opportunity to. So that, I hope, answers the things on the lien position.
Representative, I think the 6.5% versus the 4% was another question by
Yes.
Senator Furby.
Yes.
Can you talk a little bit about that?
Thank you, Mr. Chairman. I will. That language in which we get that calculation, and he's roughly correct on the calculation of that, it comes from the language in the statute that was already there. Certainly, the committee could amend it and set a different, that wasn't something that was added. It already was in the existing statute of how you calculate that interest. So it's kind of a policy decision, how much interest we would think is appropriate to accrue in order to defer these taxes. So again, absolutely correct on the fact of what that would be in today's terms, but that was already in existing statute. So I would have no problem. It's been discussed before, and they just sort of left it in their revenue. They talked about that as well.
Thank you. Any other questions? Any? Representative, if you could stick around, we're gonna go to the agency folks and hear from the director.
Sir, thank you.
I do look out and see Senator Nethercott in the back. Good to have the senator here. Director, good morning. You're in front of the Judiciary Committee again. It's nice to see you. Can you walk us through this bill from your perspective? Help us understand what this is going to mean to the department.
Certainly. Mr. Chairman, members of the committee, Brenda Henson, Director of the Department of Revenue. As the good sponsor mentioned, she has really covered the high points of the bill. We look at it as we've basically got till the 1st of November 2024 to really wrap our arms around this program, because it is a program that we have not administered before. Quite frankly, our only role in this deferred property tax program was we used to have rules on the process that counties would use to promulgate their own rules to prop this program up. We've since repealed those rules because we didn't have any discussions, any interest, and we just had the one county. So basically, this bill gives us until November 1st to come back to the Revenue Committee and provide any additional statutory changes that we deem appropriate. We also are required to promulgate rules no later than December 31st, I believe, 30th of 2024. And the program becomes available in 2025, but for all practical purposes, that means we won't have applicants until September of 2025. Now, that $200,000 amount that we see as far as a starting appropriation, just to kind of let you know some of the research we did, we do see this program in other states, the closest being in Colorado. In Colorado, they have currently about 1,100 people that are using the deferral program. Based on those numbers, we anticipate perhaps 175 statewide would be the number using this. The $200,000, basically, that would be about an $1,100 property tax bill. So if it appears as we go through this process, there is more interest, and obviously $1,100 in some counties, that's a median residential property tax amount, but in other counties, it may be significantly higher, particularly since we did the $200,000 based on half of their property taxes being deferred. And now this bill has it as being the full amount of the property tax can be deferred. But I also read the bill in that the taxpayer wouldn't have to defer the entire amount. It could be that they could just defer, they may wish to just defer a smaller amount than that. But certainly, I'm not asking for any staff, nor am I asking for programming money. I don't feel that that's appropriate until I actually see what the demand for our time is going to be. We can operate and provide this deferral process using spreadsheets, Access. We can generate letters using Word. That's my intent for the first year. Obviously, then, if we need more money, we can come back to this committee. It's interesting the way it's structured in that we get the 200,000 up front, and then we pay the taxes for those property owners seeking to defer. And then the money that they pay us back, we keep in this fund, and we continue to use that money for future deferrals. So, you know, the thought process behind that is that there's kind of this one time to get us going, and then it would just build. So with that, Mr. Chairman, I'd be happy to answer any questions, but I appreciate the opportunity to take a look at this more in depth and come back by November.
Director, thank you. Appreciate you being here. Senator Case.
Thank you very much. Good to see you, Director Henson. We've talked about a bill like this before, so I'm kind of excited to see it, to tell you the truth. Can you think of the circumstance where you might take a superior or a junior lien on the tax obligation and what the criteria would be for that? Sort of seems like it'd have to be a realistic criteria with some, some framework to that, because it can't be willy-nilly, oh, we want a first, we want a second. And the idea is I can actually see, though, the lenders, the people that hold mortgages, they want this to be successful. They don't want to see this put out towards tax sale. I mean, they really don't. So they might not mind at all being second to the taxes, because it actually stabilizes the whole property. But anyway, have you thought about that, what that might look like?
Mr. Chairman, Senator Case, excellent question. I believe that the testimony has been given that in some instances, there were property owners that wished to defer that could not get the lien holder, the mortgage holder, to sign off and release that. And so it was a block to them being able to defer their tax. But I think you're absolutely right. And I believe that we could put language in rules that would ensure that we are treating people similarly. You've got a lot of different variances out there. You know, do we want to be the second lien holder when the current upside is already, 70% of fair market value? And speaking of that, this is definitely going to require communication with the local county assessor and the local county treasurer in all of the administration of this, because we're not there. You know, we're not at the local courthouse. We're in Cheyenne. We'll do our very best. I do have some excise tax folks across the state that might be able to assist in some of this, but I think that it is important that we approach each and every tax deferral application similarly.
And Mr. Chairman,
Go ahead, Senator.
I looked at a variation of this a couple of years ago, whereby banks would administer the program and people wouldn't have to make an application to the government. Because I do think that's an obstacle. I think people don't want their counties and their people to know that they, and the idea there was that the state could underwrite and insure the financial obligations of the bank. But that was kind of complicated. I think this is probably doable. If there is a big obstacle to the getting relief from the state, so to speak, it may still be underutilized. But I'm excited what the department's been thinking about for this.
Yeah, Senator, I went the same place. And Director, that's where my mind kept going is if it hasn't been utilized up to this point, I guess I would love to hear your perspective on why 2 counties and why the rest of them have never stood up this program. And are they going to be inclined to forward opportunities for people to the office here in Cheyenne and you to make a determination? Can you speak to that a little bit?
Chairman Landon, certainly a couple of things come to mind. So first, I think one of the deterrents at the county option level was they still had to come up with half of their property tax. And I think in some situations, the taxpayer was not able to do that. So, those particular properties would go to tax sale. It buys them about 5 years to try and figure out, how to redeem those property taxes that were sold at the lien was sold at a tax sale. So I think allowing them to defer up to 100% is going to bridge some of that. Quite honestly, I have not had anyone reach out to the Department of Revenue, whether it was last year when this concept came up or this year, asking, what is the status? Now, I can tell you, I get property tax refund phone calls all day long. But this particular program, I'm not hearing from folks. So either they're not aware of it, but it's very unique. The Department of Revenue, quite honestly, we administer payment plans for, let's say, vendors that are behind in remitting their sales tax payments. We do payment plans sometimes for mineral taxpayers. So we have some of that knowledge. We place liens currently in the counties. For ad valorem tax, we actually file liens on behalf of the county for their monthly ad valorem mineral taxes. So we are comfortable administering those aspects of it. What the new aspect for us is the payment of their taxes to the entity. That's the new piece for us. And we'll certainly be reaching out to Teton County to see how they've administered that. But I don't believe it's going to be a real challenging lift for Department of Revenue staff at this point.
Thank you for that. And it feels like the communication piece is going to be a big part of the rulemaking, I would hope, by November, just to make sure that people know at the counter back in their own county, you can defer this, but here's what it means, and here's how much you can defer. And it feels like maybe folks just have not known that this even exists out there, so.
Mr. Chairman, I believe that is a correct statement. We really try. This bill does require the county assessor to work, and the Department of Revenue, to get the word out that it is a program that's available. But the other part of that is similar to the property tax refund program. There was a feeling that I don't want to go to the courthouse. I don't want to ask the county commissioners in a public meeting to defer my property taxes. But I would feel comfortable going to the Department of Revenue and having that discussion, that communication. But we'll continue. We work with county treasurers on the refund program. We'll work with county treasurers related to this program. We'll need to be in constant contact with the county assessor to see when that trigger of 1/2 of the fair market value, is pulled. And so, like I said, to me, there are a lot of moving pieces to this. But once we promulgate rules, we can always come back and amend those rules if we find that once we roll this out that we needed to clarify additional pieces. So we're willing to do that.
Yeah, thank you for that, Director. Any further questions for Senator Furphy?
Thank you, Mr. Chairman. I'm a little confused, so you can maybe help me with this issue. When the county has not paid their taxes, they put the property up for tax sale, and often people buy those, pay for the taxes, and they get an interest rate of like 18%. So they're very interested in buying those taxes when they haven't been paid for a period of time. So how does a property owner fit under this program? And then, seems to me, it's too late. If the property goes up for tax lien sale, If you could explain that to me, I appreciate it.
Director, go ahead.
Mr. Chairman, Senator Furphy, so if taxes are not paid on real estate, then you're absolutely right. Those are advertised. There's an opportunity for the public to purchase the lien on that property, and they can do so for 5 consecutive years. But during that 5 consecutive years, that property owner can pay those taxes and redeem that. But it has the ability of, if I'm the lien holder and I've paid that for 5 years, I can go through the process to actually acquire that property. Typically, there aren't other mortgages on those types of property because, as Senator Case had indicated, for the mortgage holder, they want to ensure that those taxes have been paid. So that is not the type of situation that we typically see going to tax sale. So typically it is those folks that they don't have a mortgage, they just aren't able to pay those taxes. So I don't foresee that we would have a historical lien on these properties for non-payment of taxes. I really believe that these will be the first-time situations. But we'll definitely, if we do encounter that, we'll work with those local county treasurers and consider that when we determine whether they are qualified for deferral or not. I hope that answered the question.
Senator Case.
I think if you're in this program, your taxes aren't delinquent, right?
Correct.
So there is no other mechanisms happening to run you over, to go to tax sale or to pile up. Now, I'm not sure how it would work if you're already delinquent on some taxes, but you could qualify for this current year, I would imagine, which might help and maybe that's some room where the Department of Revenue needs some leeway. If someone's been delinquent 3 years in a row, say, and then they're coming up on this, they want to qualify for this program. Well, maybe one of the rules would be to qualify for this program, you have to restore the past taxes, so you become current. And then, and that can be a relief to someone, actually, if they can get out of the past delinquencies. So I don't know, but I throw that out.
Director, comment on that?
Mr. Chairman, Senator Case and Senator Furphy, I think these are the things that as we get through this process that we need to report back to the legislature in November. Is there language that we could have in statute that possibly enables us to pay those back taxes if there are tax liens out there? But we will definitely have that report in November. And as we look to the rule promulgation process, obviously we can't promulgate rules for anything that's outside of or in conflict with the statute. So I think that we'll have plenty of time, should this pass, to come back and clarify.
Director Henson, thank you. Appreciate you being here. We may
Thank you.
fire a question in your direction a little bit later here, but I do want to keep moving this morning. Do we have any of our assessors here? I'm not picking up on any.
We have a famous author that wants to come forward.
Yeah, so I would invite anyone else to come forward on House Bill 134. Any more testimony? We've got our county commissioners coming up. So let's go to the commissioners first, and then Mr. Winnie will come to you, okay? So good morning. And we have our taxpayers here this morning. Good to see you. Who wants to go first?
All right, good morning, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. We do support this legislation. As you've heard in some other testimony, historically, 2 counties have offered this. Teton County currently has a program with people in it. I believe there are 3 individuals currently utilizing that program, and this legislation would not change that. They could still continue to participate in the program. Sheridan County also had a program at one point in time, but didn't have any uptake relative to it, and ultimately decided to close down its program. If you're not aware, county has to develop its own local regulations around this and then get those approved by the Department of Revenue before going into this particular program. And obviously, many counties have not pursued that for a variety of reasons that have been stated, including the fact that the county would have to come up with some of the funding in order to pay those taxes, and that's not going to be feasible for many counties. Mr. Chairman, what we have heard historically is that there are some things that keep people from getting into the program. You've heard about the lien status and current law, and this would change it, but there's that priority lien position. That's the primary issue that's been brought forward. In fact, the Teton County officials that were here on the House side testified to the fact that they had to deny a particular individual because their mortgage holder would not allow for the county to take that priority position. So having that secondary priority is something that I think is helpful. We did that in the mineral ad valorem space just a few years ago, where we took a secondary position and that transition, so it makes sense here. This bill takes care of some other issues. Of course, having to come publicly to county commissioners and others is often problematic for people, understandably. And so having the veil of the Department of Revenue certainly is helpful. I could go on with many other things, but we think this is a good piece of legislation and would stand behind it. With that, Mr. Chairman, I'd take any questions.
Questions of the county commissioners? Okay, Jeremiah, thank you. Appreciate it. Good morning.
Good morning, Mr. Chairman, members of the committee. Ashley Harpstreet, Wyoming Taxpayers Association. I stand before you today in support of this proposal as it stands to be sound tax policy for the following reasons. It's justified as the property taxes have increased dramatically, and this option will provide targeted and immediate relief. It is equitable as it applies to the taxpayers that fall within the required criteria. It is stable as it protects the reliable revenue stream and provides relief to those only in need by an affirmative action. It limits volatility as it is distributed within the targeted recipients. It is transparent as this expands a program currently in place and per the department should be easy to administer. Thank you. I'll stand for questions.
Ms. Harpsett, thank you very much. Anything for Taxpayers Association? Okay. Thank you, Ashley. Appreciate that. Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. Excuse me. I have a couple thoughts for you. One, these taxes are normally paid if there's a mortgage via escrow payments. And so this will necessarily, I believe, I suspect Senator Case has probably kind of touched on this, but the Department of Revenue will have to come up with some rules to allow reduction of escrow payment in lieu of those taxes that would be paid. I don't see that as a big deal, but I just make the remark. Second comment I have for you is, since the counties are made whole on their revenue with this, I offer you that interest or tolling of interest against the due taxes or the deferred taxes should not be assessed. And again, I think you ought to do that. You could do that by rule, although the legislation ought to include something so that the department has a basis for that. Making rules changes in my time as a commanding officer on ships is a stroke of a pen. Perhaps the civilian world is a little bit more ponderous, but nevertheless easier than legislation. Subject to your questions. Thank you.
Thank you, Mr. Winnie. Any questions? Appreciate your comments, Bill. Thank you. Anyone else want to come forward on House Bill 134? Anyone else want to testify? Here, do we have anybody online? Okay. Representative, any final thoughts? Okay. All right. I'm going to close public testimony. Committee, what is your pleasure on this bill?
Do pass.
Okay, do pass by Senator Cooper and Senator Case simultaneously. We'll write down Senator Cooper. Discussion on the bill, committee.
Chairman.
Senator Furphy.
Thank you, Mr. Chairman. I'm going to be a no vote on this, mostly because of the lien positions. I think needs to be refined a little more, and some of the other issues. The original bill was okay in my mind, but these amendments, I think, need a little more work, so I'll be a no vote.
Okay, thank you, Senator. Any further discussion? Any amendments? Senator Case?
Well, Mr. Chairman, I mean, it was brought up about the interest rate. Why don't we have a discussion about that? So, yeah, but the relationship between the, let's just be clear about this. The deferred taxes, they actually do get paid. And the state pays the taxes, so the county is whole. And all the special districts, everybody is whole. The question is, what is the opportunity cost for the state? I tend to, support, treasury and market-based things. We are in kind of an unusual time period with respect to interest rates. We might think about having a lower interest rate for the first couple of years and thinking that the market is in the world of interest rates are going to stabilize. And what I'm getting at is in economics, one of the most steady long-term measures is the real rate of interest over time. It runs about 3%. I mean, you can do it over hundreds of years and see that. But we're in an upside down world with all this inflation, and nobody's quite sure. If you believe that interest rate, that inflation is like 2% right now, you might think that the rates are really too high. Probably inflation is a lot bigger than it's actually being measured. But I just wonder if we might want to have a separate rate that would apply just for the first 2 to 4 years of the program. And I'll just throw that out. And if anybody wants me to propose that, I could be more specific.
So that would, Senator, that would probably come in under paragraph
D
D on page
page
5, become the new E, and something to the tune of, for the next, up until 2027, X, Y, Z. Is that where you're leaning with this?
It'd be, how about something like this, Mr. Chairman? Notwithstanding the rest of the language in D, the maximum rate would be 4% until, and we want to follow tax years, I would just say January 1st, can we say 2028? Or I can go farther, I don't care. So that just caps it at 4%. And it's a maximum, so that if real interest rates drop, treasury rates drop, it could go
So
down
Pierre,
too.
did you get that?
You bet. Mr. Chairman, with your permission. Pierre, we could either do it as just a sentence at the end that would say, notwithstanding the above language in this section, the maximum rate shall be 4% until January 1st, 2028. And I don't want to mess this bill up late in the day, but do you think the House would go for it? I think so too.
So, Senator, I would think, and talking to Pierre as well, I think on line 12, maybe that comes in after the word made. And then,
That's fine. That's probably a better place for it. That's friendly.
that just adds that, I'm looking at the sponsor of the bill. Does that track for you, Representative? Okay. Okay. Senators, are we good with that
Yeah, and
amendment?
just for the folks online, the sponsor indicated that the chairman's proposal to put it after the word made on line 12 of the green copy.
So there's, Senator Case's amendment is on the table. Any further discussion? All in favor of Senator Case's amendment, say aye.
Aye.
Any opposed, no. That amendment has passed. We're back on the bill. Anything further on this one? House Bill 134, please take roll. Here, if you would.
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
No.
Senator Schuler.
Aye.
Chairman Linden.
Aye. So Senator Cooper, I see your name on this one. Are you perhaps going to get with the representative and bring it to us upstairs? Because we look forward to that. Yeah, that'll be good. So House Bill 134 goes to the Senate. It likely will be re-referred real quickly. I'll check with the chairman of appropriations, but I think it probably needs to be re-referred. And let's move on to House Bill, what's next?
90.
House Bill 90.
Do people care about guns?
Turn them off.
Child safe haven?
Representative, good morning. Welcome, and please walk us through House Bill 90.
Good afternoon, Mr. Chairman and members of the esteemed Judiciary Committee. I bring to you House Bill 90, Newborn Child Safe Havens, Age of Child, and ask for your favorable consideration. And I'd like to explain the bill, if I may.
You're green and you're close, right?
Yes.
Okay, so everyone can hear you. Thank you, Representative. Please continue.
Thank you, Mr. Chairman. Mr. Chairman, safe haven laws have been developing and undergoing revisions for well over 20 years in the United States. And each state establishes its own criteria under their safe haven law. Many specify locations and age cutoffs for infant relinquishment. What this bill specifically does is it amends current statute 1411-102 by increasing the age a baby may be relinquished from 14 days to 60 days of age or younger. Why the change? Mr. Chairman, with the prevalence of substance abuse and mental health issues, including postpartum depression in our state, an increase in the baby's age helps prevent and save babies from unsafe abandonment. So it just increases the window again from 14 days to 60 days. And I would stand for any questions.
Thank you, Representative. Questions of the sponsor? Senator Schuler?
Thank you, Mr. Chairman. I guess maybe I just need a little more clarification on, I understand what you're saying in terms of the postpartum issue, but when I read through this bill, my first thought was, are we going to discourage people from dropping a baby off at a fire station or a police station? Maybe mom's found out within the first 2 or 3 weeks that she can't handle the baby. So I was a little concerned about bumping it up to 60 days and just wondering what your thoughts were on that.
Maybe just, Representative, dig a little bit deeper and let's visit about that 60-day time period. I kind of had the same question as to, that baby's been around for a while. So anyway, help us understand why the 60 versus 14.
Yeah, thank you, Mr. Chairman and Senator Schuler. So obviously, the purpose of a safe haven law is to save babies from unsafe abandonment. The law states that parents who do not harm their infant will not be prosecuted for abandonment if they hand their newborn over to a responsible adult at a safe haven location. When you think about a 14-day window, that's a 2-week-old baby. And often things change in relationships, things change when it comes to dependencies, such as substance abuse and mental health disorders as well. And so, again, this extends the window to offer another mechanism for moms that are struggling. And I believe, accommodates them when they're in these terrible situations and need to make a life-saving decision. I hope that answers your question.
Any follow-up? So I'm wondering, was there any conversation on the other side, Representative, with regard to a fairly unsafe environment, if it's what you just referred to? You've got a situation where you may have some substance abuse going on. Any concern that this child is then going to spend 60 days in that unsafe environment? Does the 14 days encourage that if the mother wants to give this child up, that she would do so before any more harm would come to the child? Is there any concern on that front? That's another 30-some days. You know, that's quite a few days to. Any thoughts?
Mr. Chairman, members of the committee, the age window to relinquish an infant, a baby, varies across the nation. So we have seen anything from, again, 14 days all the way up to, I think it was 16 years. The House Judiciary did a little research on age.
So you're talking about state by state?
Yeah,
Oh,
yeah.
okay.
And when you think about relinquishing a baby, I think, again, the wider the window of opportunity to place that baby into a safe environment is all the better. However, we do know that parents later on down the road do have the opportunity to, if they choose, to terminate their parental rights and place a baby for adoption or make an adoption plan for a child later in life.
Thank you. Anything else, committee? Okay, Representative, thank you. Let's go to any further testimony on House Bill 90.
Mr. Chairman, I'm wondering if the Department of Family Services is here, and I just see that they are in the very back. I'm sorry.
My mistake on that front.
Yeah.
Thank you, Director. I did not see you back there.
So in the law, it's the Department of Family Services that has a big role in this.
Very much so, and I did not mean to overlook our agency, so.
And they have to pursue termination of parental rights. There's a lot to this.
Yeah, it's substantial. So Director, welcome. Thank you for being here.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt, and I'm the Director of the Department of Family Services. And really, I'm just here to answer any questions because the department is given custody of the child when a child is given over under this law. To Senator Case's points, yes, we will give the parents 3 months to make a determination about coming back for the child. And if at that point they do not, we will go to termination of parental rights, and then that child will be placed for adoption.
So I'm just trying to get my arms around that. So if someone abandons a child, they have 2 months to decide if they did the right thing or not. In the meantime, where does the child go?
Foster home.
Mr. Chairman, yes, they have actually 3 months to make a determination if they would want to go back for the child. And then at the moment that the child is given to a safe haven provider, and a safe haven provider is an entity such as fire stations, sheriff's office, hospitals that run 24/7 and can take the child into care. Then they will call us, the department, immediately, and then we will take protective custody, place the child in foster care until that time that the issue is resolved. Either the parents come back or the 3-month timeline expires, and then we'll file in court to terminate rights.
Any concerns with the language change in this bill that would extend that time period out to 2 months?
Mr. Chairman, No concerns, mostly because we do not have a lot of children that have been relinquished under this statute. I mean, I think we've had 5 over the last 10 years or so, so it's a small number. Looking around our sister states in the general area, it varies, the timeline varies from 3 days, like what ours currently is, or 3 days, 72 hours, up to 30 days, 60 days for some. So as the good representative mentioned, it really is all over the place. So this seems to fit within that. And so we can work with it however we need to.
Thank you, Director Smith. Anything else, committee?
And Mr. Chairman,
Go ahead, Senator Case.
Director Schmidt may not have heard. So they're placed in a foster care in the intermediate time, right? Yeah, those are wonderful people that take that on, and it's hard to take a little baby in your life and then give it to a permanent home or give it back, or that's a hard thing. Those are good people.
Yeah, Director, we appreciate, be sure that all of your folks over in the agency know that we appreciate what they do. Appreciate all those people out across who help you do it. So, anything else for the Director? Okay, go ahead, Senator Cooper.
Thank you, Mr. Chairman. Director Schmidt, can I get a department position on, is 60 days the right number? Should it be 30 days? Should it be, is there something we can do to better zero in on that timeframe? Or is 60 the correct number?
I was thinking 18.
Age 18?
The age of 18?
How about age 70? I think that would
Yeah,
probably be
little
better.
sidebar, we're thinking about increasing that. Director Smith, go ahead.
Mr. Chairman, Senator Cooper, there isn't a lot of research that shows what a good date is, what a satisfactory number would be. So I'm hesitant to give you any guidance on that because it's just speculation at this point. I do know that Nebraska had originally had it up to age 17 or 18, and what they were seeing was the relinquishment of teenagers. So 1870, I think sticking somewhere around that 30 to 60 day mark would probably be best for us.
I suspect you're right. Senator Case.
More. So this doesn't affect child support, presumptive child support, anything like that. So there would be, say, someone that would be expected to provide child support under either arrangement, that would stay the same, right? This is not a tool to get out of child support.
So, yeah, good question. Does the child support follow the child upon abandonment?
Mr. Chairman, Senator Case, no, this would not require that parents would have to pay child support. That's kind of the get out of jail free card, is that if they voluntarily relinquish under this law, then there's no penalty. And we'll double check that because we haven't been asked that question, but the spirit of the law says you have within right now, 2 weeks to give up custody of your child to the state without any fear of any type of penalty, which would include any other civil proceedings. I will double check that and let you know. So even after termination, parents are no longer held to a child support requirement. So once termination occurred at that 3-month mark, then the parents wouldn't be required. But it is a very good question. So let me dig into that one a little bit more about the child support, because I don't believe we would even pursue parenthood, presumptive fatherhood, or anything, because the spirit of this is really just to say, if you don't think you can take care of your child, we are giving you a place where you can give that child up without any fear of consequence.
So,
Go ahead, follow up, Senator Case, and then we'll go to Senator Furphy.
well, sort of a negative hypothetical is, say it's an unmarried couple. Maybe there's a tenuous relationship between them. The father is potentially liable for for child support, but the father convinces the mother that what we need to do is to give the child up. and he might do it for the wrong reasons. On the other hand, it all might work out for the best and be the right reason in the end. I get that. I do understand that. But there's kind of interesting incentives for a very young, very confused, and possibly not the most upright young man in this scenario.
Senator Furphy.
Thank you, Mr. Chairman. Director, let me ask about adoption. Seems to me a young mother who has to make a decision within a 2-week period is more likely to give up for adoption to a couple who is well qualified. If the single mother keeps the baby for 60 days, she's probably a little more reluctant to give the baby up for adoption. Do you have comments on that?
Director Smith?
Senator, or Mr. Chairman, Senator Furphy, the relinquishments that we've experienced have been at the hospital upon birth, for the most part. So I think maybe in response to that, if there's a consideration of adoption, it's made at that time where the parents decide at the hospital that they no longer want a parent. I would hate to speculate on what the mindset of the parent would be at 60 days post-birth to make a determination whether adoption would be an important component of giving up custody at that point. But it is still available. It would be available.
Further questions? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. I think maybe knowing that at 3 months they can change their mind, I do feel a little more comfortable about the 60 days. At first I didn't, and I think the more I think about it, it makes more sense. And so I do appreciate the amendment. Thanks.
Okay, so please stick around, Director. Thank you for being here. I'm sorry I didn't see you in the back. Anyone else wish to testify on House Bill 90? Anyone else? Mr. Winnie, please come forward.
Mr. Chairman, Bill Winnie, Sublette County. I'd like to offer you a thought in turning this around and looking at it through the eyes of the infant. If substance abuse is involved, and that's been a common thread in testimony so far, there's a decent chance that infant was born addicted and needs medical care, and in fact may be one of the reasons that the parents are not sure they want to keep it, because it can be really tough to handle a baby like that. So subject to your questions, thank you.
Thank you. Any questions? Okay. Yes, sir. Good morning.
Good morning, Senator, Chairman, and members of the committee. My name is Steve Milia from Cheyenne, Wyoming here. And I'd just like to say that
Steve, what was your last name?
Milia.
Milia.
So like Amelia Earhart, just no A on the back.
Thank you.
I said that to some students one time, and they had no idea who she
Sorry
was.
to interrupt you. I just wanted to make sure we had your name.
Oh, that's okay, sir. Thank you. I stand in support of this bill, and as Representative Rodriguez-Williams has stated, I agree with what she says, and I appreciate her bringing forth this bill.
Okay. Any questions? Mr. Amelia? Thank you for being here. Anyone else? Is there anyone online who'd like to testify? Nobody? Okay. Thank you, Pierre. I'm going to close testimony, and I already have a do pass by Senator Case on House Bill 90. Any discussion, committee? Any amendments? Pierre, please take a roll on House Bill 90.
Senator Case?
Aye.
Senator Cooper?
Aye.
Senator Furphy?
Aye.
Senator Schuler?
Aye.
Chairman Linden?
Aye. Representative Rodriguez-Williams, do you have someone lined up who would like to present this upstairs in the Senate? If you'd like to check with them, and if for some reason they balk at the opportunity that we're giving them, just let me know, okay? Thank you, Representative. Okay, House Bill 92, protection of parental rights. Representative Stiff, there you are. Come on forward. Welcome.
Mr.
Good
Chairman,
to see you. Thanks for taking a moment out of the major league discussions that are going on here in the Capitol as a member of our Appropriations Committee on the other side. Walk us through House Bill 92, Representative.
thank you, Mr. Chairman. This bill is very similar to bills that were brought in 2022 and 2023, with the difference that this year it's streamlined to focus on the K through 12 issue and communications by the school district to parents concerning their children in school. So page 2, on line 2, we've added the phrase, including all courts in the state, as being subject to the existing statute, which is 14-2-206A. The existing statute not printed here, the portion not printed in the bill, says that the parental right to the care, custody, and control of their child is a fundamental right. So that sentence doesn't show up in the bill because it's not being changed. Subsection B, which we are changing, makes it apply to the courts. And that's kind of an odd thing to say, and you would think it's unnecessary because the statute as it exists right now already applies to all state agencies. And as you may have noticed in your budget bill, the courts are an agency of the state. But our Supreme Court, for whatever reason, issued an opinion in February of 2020 appearing to say that they didn't think they might not be an agency of the state with respect to this parental rights statute. So from my point of view, it's just clarifying that yes, courts are a state agency for purposes of this statute. The next lines on page 2, 8 through 13, essentially just say that schools, basically, are a state agency for purposes of the parental rights statute. And you might wonder, why would we have to say that? Well, it arises out of that same case where the Supreme Court said this parental rights statute is in Title 14 of Wyoming statutes, which deals with children. In that particular case, they said because it's in Title 14, it does not apply to Title 20, divorce actions between married people. And so fair enough, but that also implies that if we don't say this, then this parental rights statute would not apply to Title 21, where schools show up. So that's the reason that these lines 8 through 13 are there. And then what I think of as the more operative function of this bill is lines 20 through 22, that says that the Board of Trustees in each school district shall require communication and disclosure to a parent or guardian regarding their student to ensure the protection of parental rights under Wyoming Statute 14-2-206. So the specific goal of this is to deal with the same problem that you dealt with, I think, in Senate File 9, and it arose in my district back in Rock Springs, where you had the school district taking the position that it was not obligated to inform parents, and indeed the school district adopted a procedure saying that they would not inform parents of the preferred pronouns that the students chose. So this bill is designed to at least include that, so to make clear that for something, fundamental to raising your child, that the school district would be obligated to inform the parent. I've put together this chart here because I got a question from LSO staff as to how this bill relates to what you dealt with a couple weeks ago now, and that I think is on a path to passage in the House of Senate File 9. I like Senate File 9. It was a committee bill. The Education Committee did. I think it's a good bill. I support it. I think it's great. I think both the House Bill 92 is very similar to Senate File 9. It deals with sort of a similar set of concerns. They're similar, but they're not the same. And I think House Bill 92, it does not conflict with Senate File 9. So there's nothing in this that conflicts with what you've already done. And then I think House Bill 92 has the added advantage in two ways. And so I put this Venn diagram together. The gray shaded area, or blue on mine, indicates the overlap between the two. On the left side, where I've got the dots, those are things that I think House Bill 92 covers that would not be in Senate File 9. And one of them relates to the courts being obligated to this, because Senate File 9 says, it says that it makes a reference to this statute, 14-2-206, but it doesn't say that schools are actually subject to it. And given what our Supreme Court has already said, I'm concerned that the Supreme Court would say, well, of course we're doing this in accordance with 14-2-206 because 14-2-206 doesn't even apply to schools, right? So it fixes that problem. That's in the, what I think of as the dotted portion of the Venn diagram. And then the other portion is, and these are perhaps more theoretical than real, but it's possible that a parent's fundamental right might require certain communications that are not specifically listed in Senate File 9. To be honest, I can't think of one, right? So I don't know how big this slice over here on the left, I'm not sure how big that slice is. And similarly, on the right side, things that might be, communications that might be implied by fundamental parental rights in 92 that may not be listed in Senate File 9. And to be honest, I can't think, well, let's see. It's possible that Senate File 9 imposes a specific disclosure obligation that wouldn't necessarily be compelled just by the fundamental right itself. So hopefully this is helpful and not confusing. I think House Bill 92 does no harm. I think it complements what we've got going in Senate File 9. So I would stand for any questions.
Any questions? Senator Schuler?
Thank you, Mr. Chairman. First of all, I really like your Venn diagram. I'm really impressed by that. It's really cool. Secondly, the only question I have is the obligations not implied by fundamental parental rights, does that include our 18-year-olds? Because there is that, confusion there with the 18-year-olds. Do they have to, let mom and dad know how things are going at school or not?
Mr. Chairman, Senator Schuler, that's a great example. I think that you hit the nail on the head to the extent that Senate File 9 applies to 18-year-olds who are enrolled in high school, for example. I'm not sure House Bill 92, House Bill 92 would not apply to that situation, I think, because the age of majority is 18. So that's a great example of an example of what's in the right portion of the Venn diagram. Thank you.
Any further questions? So I've got one, Representative. You go to the language at the bottom of page 2. I'm just trying to think out loud with you. Real life circumstances where, having been in educational administration for much of my life, albeit at a little different age group, I had them a little bit later in life, but I'm just wondering if this is ever going to compel something that we really don't want compelled. Did you think about that going through as you drafted the bill?
Mr. Chairman, yes. and what we don't want to compel disclosure of something that would harm the child, right? You can imagine situations where one of the parents or step-parents is a perpetrator, right? And you don't want the school district to, and the child's a victim, you don't want the school district to be required to call up and make the first phone call to the alleged perpetrator, right? And I think how that gets covered in this bill is under existing statute on page 2, lines 4 through 6. Well, actually 5 and 6. So the whole phrase, of course, says the state shall not infringe the parental right as provided under this section without demonstrating that the interest of the government as applied to the parent or child is a compelling state interest addressed by the least restrictive means. And so in the instance of, say, abuse or neglect or alleged abuse or neglect or suspected abuse or neglect, I think that's the out for the school district and the administrators. And I freely admit that this language is pretty vague, okay? It's like due process, right? And that's could present a challenge to a school administrator knowing, well, what does this House Bill 92, what does it really mean? And so I think that's potentially a challenge, but I think that's a challenge that we face in other areas of, frankly, society and the law that I think we work through. I don't think it's an intractable problem. That's why I like Senate File 9. I like it for its specificity. I think if I'm a school administrator, what I would typically do as a school administrator is that I would look to Senate File 9 for my laundry list, and then when you get to really thorny or unusual situations, you might rely upon House Bill 92. That's kind of my shorthand of how those two would work together. I'm hoping that both pass.
Just the concern always is that something we do here might discourage, some young person from coming forward on any level for any reason. And there are a lot of times, that a young person will say, I'm coming to you, but I can't let my parents know this. And any concerns that we're locking something down that would prohibit any of our young people from being able to come forward and find somebody?
Mr. Chairman, that's a legitimate concern. I don't believe that this, as it's written, requires if the student makes a disclosure to a teacher and says, for example, I've been smoking and I think I'm addicted to nicotine and I'd like to sign up for your nicotine patch program, right? Right now, specifically, that does not have to be disclosed to the parent. And I don't think this changes that because, again, I think the out is up here on lines 5 and 6, where you've got the compelling state interest. And again, that's my interpretation of what this means.
Sure.
And so I admit that, that this language is broad. When 14-2-206 was initially debated, it was before my time in the legislature. But one of the reasons that people voted no or argued against it at the time, it's my understanding, was to say that we don't need 14-2-2-206 because it's already the law. It's already constitutional law that the parental right can't be infringed except by a compelling state interest with the least restrictive means. So for that reason, and I think there's some merit to that, right? I mean, I think 14-2-206 was useful to clarify the parental right in Wyoming and codified as a statute as opposed to the US federal Constitution. I think this is workable. If it turns out this becomes the law and it's not workable, well, then we revisit it, but I don't think it does harm.
Yeah, I appreciate those thoughts. And by the way, I've always been a parental rights guy, in the Senate. I just was thinking out loud with you that you sure don't want to box one of our kids into a corner where they really don't feel like they can go anywhere. Anything else for the sponsor, Senator Case?
Thank you very much, Mr. Chairman. I'm trying to understand how the big picture all fits in. So I know that in certain circumstances, minors have access to the courts, and the courts provide confidentiality back to the parents. I know there are health situations that occurs. I also know that there's, and I'm not very good at this, but there are minors that have been emancipated. And so, and it's more common than I thought it was, where, the court decides that they can be treated as adults due to whatever factor the court takes into consideration there. How do those circumstances fit, and do we need to recognize those?
Mr.
Go ahead,
Chairman,
Representative.
Senator Case, you raise a great point that where someone who's under 18 has been emancipated by statute, then I believe reading this House Bill 92 with those other statutes would mean that the parents' rights to information would stop. I think. I mean, I think that's how it works. I think that the parents' fundamental right will have been changed by the emancipation order. If that answers a portion of the question, there may be a second portion of the question that I have not addressed.
Yeah,
Go ahead, Senator.
it's not obvious, but there might be another way somewhere else where the emancipation works through to make that happen. You know, we could add the word applied to the parent. I mean, we could make it an unemancipated child somewhere. And I'm not sure where to do that, but that would definitely nail that down.
Mr. Chairman, Senator Case, I would regard that as a friendly amendment, especially if you made the amendment down on the lower half of page 2. You put it wherever you want, I guess.
Well, help us.
I don't have a, you could on line 13, before the word child, insert the word unemancipated.
Let's pencil that in and we'll take that up. And then in the situation, so I know that, Mr. Chairman, I'm kind of on thin ice, but I do know that courts uphold parents' rights already. I mean, it's a high bar, and there has to be, I'm not sure what the legal standard is, but it's more than, you know, help me with what the statutory bar is, whatever this doesn't affect that. This won't weaken that or strengthen that, will it?
Go ahead, Representative.
Mr. Chairman, Senator Case, the confusion that's arisen, I think, in the courts is that there's a U.S. Supreme Court decision that you're likely very familiar with called Troxel that dealt with effectively grandparents' rights, where the state court in Washington had said, hey, the child is better off with the grandparents, and so therefore grandparents, you get the child, and effectively terminated the biological parents' rights. And the Supreme Court ruled that that went too far. You can't just do that, that there are parental rights at play here, that you can't do that without showing that the parents are unfit. So that was that case. But the way the opinion was written, there were at least three different opinions in the majority. And so there was no clear standard that everybody can agree upon. One of the standards in that sort of balkanized Supreme Court opinion, one of the standards that, and I can't remember which justice or set of justices did it, was what became 14-2-206. And so as applied in the courts of Wyoming, what you find typically are the Supreme Court saying, we will not alter the child's best interest. We will not sacrifice the child's best interest at the altar of parental rights. That's a phrase that gets used a lot, right? And it's a kind of an aphorism, and I don't disparage any of the results of the decisions that the Supreme Court has made on that, but it's created this odd situation where our Supreme Court, as a practical matter, has focused on the compelling state interest prong of this, but they typically do not discuss the least restrictive means prong. And there are two prongs in existing statute. This bill doesn't change that. There are two prongs to this test. One is when the state wants to infringe on the parental right, is there a compelling state interest? Usually that's the best interest of the child. But the second prong is that what the government is doing so by the least restrictive means. And that's the prong that frankly tends to get kind of falls by the wayside a little bit. And as far as 14-2-206 goes, it was adopted in 2017. There's been no case in Wyoming, district court or Supreme Court that I'm aware of, that has actually has actually applied our existing 14-2-206 in any case. It's just been ignored. And one of the reasons it's been ignored is because in 2020, the court said, well, this doesn't apply to us.
21, yeah.
And so that's my sort of personal view on it is I frankly just didn't like it that the court said the law doesn't apply to us. I mean, obviously they didn't say it that way. I mean, they didn't actually say that starkly, but I didn't like the music of it. So that's why we have the including all courts in the state in this bill. Does that answer the question?
So, Mr. Chairman,
Go ahead, Senator.
slight read back on that. So the existence of the compelling state interest language is sort of the filtered down rulings of all that saying parental rights are paramount in the absence of a compelling state interest. Would that be the rarefied
Mr.
bottom level?
Mr. Chairman, Senator Case, I believe that's the current state of the law right now in Wyoming. This does tweak it slightly by saying, okay, fine, child's best interest, that's a compelling state interest. But whatever action you take that interferes with the parent's rights, you need to use the least restrictive means to do so. And it's that least restrictive means prong that I think's important. Now, that doesn't translate obviously into the K through 12 school context very smoothly. Okay, and I admit that there's a challenge with this bill, and the challenge is it's kind of vague, right? And that's why I like Senate File 9 as a complement to it. I think they actually go together.
You know, on that front, Representative, there are a lot of our young people pretty grown up at 16 and 17. And I assume that by 18, we're not talking about this bill, but yeah, really appreciate your thoughts this morning to kind of flesh this out for us. I want to get to some other testimony. We're running well along on the clock, and please hang tough for a minute if you can. Do you need to get going?
I do have actually other meetings I'm supposed to be at right now.
Please go.
Thank you so much.
Trust us, we'll take good care of you.
Thank you.
Yeah. I'm sure he does trust the senator, right, Jay? Yeah. House Bill 92. Do we have anyone else who would like to testify on this bill? Looks like maybe our school boards might come forward on this one. So welcome to both of you. Let's start with our school boards first. Good morning, Mr. Farmer.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association. Mr. Chairman, really, we don't take a position one way for or against this, but in light of your discussion, just wanted to offer some additional thoughts. The area of parental rights, student, parent, school communication is a complex area. I would imagine there's probably a couple of additional circles you'll want to add to the Venn diagram that I haven't seen. I want to remind you that there is the federal law, of course, that guides and pertains to this. So you have FERPA, the Family Education Privacy Rights Act, and that protects the parent and student in many ways. And then the section of federal law that comes right after that is pupil right protection amendment. So those two sections really have a lot to do in federal law with guiding the communication between the school district and the parent. And so there is already a fair amount there. And really when it comes to things that are collected by the district, records created by the district. And when you're talking about the physical well-being, federal law is very clear about that. The area that is not as clear under federal law now comes into sort of the mental health relationship and that piece. And so that is where Senate File 9, the additional piece of legislation out there, has provided some additional guidance with regard to that. But beyond federal law, then you also have laws governing professions. So when you have counselors, and you're talking about the laws governing the client and parent communication for counselors. So if you have a school counselor, they're still bound by sort of their professional code and communication that they have with the parent and they may be employed by the school district, but they're still also bound by codes of their profession. So it is a complex area of law, and I think this legislation does provide some additional clarity, but it certainly does not answer all of the questions that are out there. You've had some good discussion around those, and really just wanted to be available if you wanted to ask any specific questions with regard to school districts.
I appreciate that, Mr. Farmer. Thank you. You're exactly right. There's a lot of reading in this area of the world. Any questions? Okay, good morning, sir.
Morning, Mr. Chairman, Senators. My name is Richard Lennox. I'm a retired teacher, and I run a small business here in
Richard,
Cheyenne.
can you give me your last name again?
Lennox, Lennox. I was watching online, so I kind of ran over, so I apologize for my appearance.
You don't have to apologize for anything.
All right.
For being here, go ahead.
Two different directions I want to go in here. And the first one is, I think Senate File 9 does complement something, but it complements statute already here. It says right there on page 2, line 1, any agency. And obviously, our schools are agencies of the state. So I think it's redundant. But let's then pretend that it is needed. My concern is once you marry this statute to 14, I think it opens the door for conflicts of which parents' liberties are we going to uphold. Parents obviously have the liberty to direct their children's education, decide what schools they go to, what programs they're enrolled in. But when we start getting into those schools and into those programs and start looking for ways to direct the lessons plan, the education, the communication, which parent of which child or which student has higher liberties over the other? Is one parent's request to a school greater than another set of parents' request to the school? So once we put these two together, that is my concern. They have, parents' rights are great. They're spelled out in Statute 14 of the care, custody, and control of their child. But I think it gets a little murky when we try to marry it to Title 21, when you're dealing with 30 sets of parents within a classroom or hundreds of sets of parents within a school. Which parent's liberty takes precedence?
Questions? Mr. Lennox, thank you.
Thank you.
Appreciate it. Anyone else wish to testify on this bill? Is there anyone online who wants
We
to
have
testify?
2 people online.
Okay, if you could let them both in, maybe Pierre, and we'll go to each one of them. Okay, let's go to it's Miss Pearson. Let's go to Miss Pearson first.
Hello, can you hear me?
Welcome. Yes, we can. Welcome to Senate Judiciary this morning.
Hi, Mr. Chairman and members of the committee. My name is Laura Tolliver Pearson. I'm from Southwest Wyoming. I would urge an aye vote on this bill. As Representative Stith mentioned, we did have issues in Sweetwater County. I think one thing that a lot of people are overlooking in this, as far as parental rights, is if a parent sues a district over things that they feel were done wrong in their district, they really have no avenue to win a case. So we need something actually in statute that protects the parents, because obviously if parents get an attorney, they have to pay for all of those legal bills. Whereas the school district has their own attorneys and they have virtually unlimited funds, to combat these lawsuits. So we need something in statute that protects parents. So I would urge an aye vote on this.
Okay, thank you for zooming in this morning, and it looks like you've got some help there, and
I do have help, lots of help.
Yeah, that's a good deal. So thank you for being with us. Any questions, Ms. Pearson? Okay, let's go to Ms. Pavey this morning.
Oops. Good morning, committee.
Good morning. We can see you and we can hear you.
Perfect. My name is Laura Pavey. I'm from Southwest Wyoming, and I am in support of this bill. Parents, I do know, have had very hard time taking school districts to court because schools often can say that they are in the best interest of the child. And whose best interest is, there's a perception there that's torn in our society right now. The school's best interest might not be the parent's best interest all the time. I mean, we saw that happen in Rock Springs. And so this just, I feel like it gives a little bit more of a standing. I know that oftentimes I've talked to parents around the state of Wyoming and they can't find an attorney that will represent them because of our state laws. A lot of parents in our state can't afford to take the school districts on. And that's not also something that happened in Rock Springs. And so I just urge your I vote. And I hope that maybe in the future, our legislature can pass something that helps parents be able to afford to take a school district to court if they have been wrong. And I'm not saying our school districts are bad. I'm not saying our teachers are bad, but there are sometimes cases where parents have been wronged and they have no legal avenue.
Ms. Pavey, thank you. Appreciate you taking time as well.
Thank you.
Zooming in today. Any questions of Ms. Pavey? Thank you very much. We really appreciate it. Okay, anyone else online this morning? Pierre, and nobody else in the room want to come forward on House Bill 92? Okay, let's. Hey, please state your name again for us. We know you, but.
Good afternoon, Mr. Chairman, members of the committee. My name is Steve Milia from Cheyenne, Wyoming. As a former teacher some years ago and as a public health education and as a parent and a godparent, I would stand fully in support of this bill. I really would like to know everything about my child, my son or my daughter, when they're going through. They had some problems. The school communicated with me. They didn't hold anything back. We were able to resolve the problems. And keeping things from parents is wrong. Now, if there's a bona fide problem of some sort of abuse, there would be some evidence of it one way or the other. There are policies and departments that are set up to take care of this. But keeping secrets from parents is like, are the parents really the enemy? As the last speaker just mentioned, there's a thing going around the country that parents are the enemy and we can't trust parents. So I would look at all of you and going, well, when you were parents, you were the enemy because you didn't know anything. And suppose you were a teacher and a parent. Well, which side of the aisle would you fall on? Well, you're a teacher, we can tell you. No, you're a parent, we can't tell you. So I think parents need to be trusted. And if there is signs of abuse and whatnot, they can come out and they can be handled by the proper departments and whatnot. So I stand fully in support of this bill. And I think all of you are probably excellent parents. So you should have known everything that's going on.
Well, thank you, Mr. Mealy. I appreciate it. Thank you for your testimony. Okay, we're going to close public testimony on House Bill 92. Committee, what's your pleasure? Moved by Senator Cooper. Discussion. Any discussion? Committee, I'm all for the parents' rights, and I'm going to support this bill, but I really appreciate some of the things that have come up this morning. This is not easy, and it's not a slam dunk case at all when you consider this bill. It's, as Mr. Farmer pointed out, we've got all kinds of federal legislation that comes into play here. We've got all of these, ethics and codes of conduct for folks like professional counselors, and so it's pretty murky water out there. But anyway, are you ready for the question on the bill? Is there anything on the bill? Senator Case.
Mr. Chairman, I think this is more complicated than we know, and I wish we could spend more time. And this is like interim topic time where you, I'm not sure I'm opposed to anything here. In fact, it sounds like a good idea to clean it up, but I just didn't feel that it's clear enough. And maybe that's, I'm a little worried about that. I'll probably support the bill to get out of committee, but I'm not an enthusiastic yes.
Senator Cooper.
Thank you, Mr. Chairman. I'd have to concur with Senator Case. Even if this bill moves forward and passes the Senate, I think this is something that needs to be seriously addressed in interim and really look at what we're doing here. I'm not sure that that this is as black and white as a clean bill coming from the House appears.
Yeah, I agree with the two senators to my right. Anything, Senator Schuler?
Well, again, thank you, Mr. Chairman. I think we have a lot of things in our statutes that cover a lot of this, but obviously with some of the issues that have happened over on my side of the state, I see where the bringer of the bill is coming from. And I guess my big issue right now is as long as HB 92 doesn't conflict with Senate File 9, if it helps, I guess I'm good with it. But again, I think it is a very complicated issue, and I also agree that maybe we need to do a deep dive into some more of information in the summer and see if we can even clean it up more.
You know, we will take up, I think, Wednesday morning committee interim topics, and I agree with Senator Cooper. This is one that we may want to learn a little bit more about. And having spent a lifetime, it seems, you know, in education, I can tell you that all of those things come into play, and it's a pretty challenging world. So anyway, so Pierre, would you take roll on House Bill 92?
Well, I want to do that amendment.
Oh, okay, I apologize. Senator Case.
Yeah, Mr. Chairman, I would move that on page 2, the white bill, line 13, before the word child, we put unemancipated.
Unemancipated.
I think that's well-defined elsewhere in the statute.
Any questions about what that amendment would do, senators? Do you have that, Pierre? Got it? Okay, all in favor of Senator Case's amendment, please say aye.
Aye.
Any opposed, no. That amendment has passed, unemancipated in front of child on line 13. And we're back on the bill. I apologize, Senator Case. I had forgotten we talked about that.
You've been out of practice a couple of days, Mr. Chairman. I'll get you split.
Yeah, I've been running around elsewhere. So now let's take roll on House Bill 92.
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy, Senator Schuler,
Aye.
Chairman Linden.
Aye. So House Bill 92 will go to the Senate. I assume that maybe the senator from Sweetwater County will be the one carrying this upstairs, but he can come to me if that's a difficulty. Unfortunately, folks, as predicted, we are not going to get to House Bill 125, and I assume that everybody in here is probably sticking around for that bill. And that's the way it goes on this final day of getting bills out of committee for our good friends over on the House side. We got 3 of them out of here for our good friends, and we've got 1 left. And so we're going to have to take that up, Representative, this evening upon adjournment. And so we'll spend this evening together, everyone. Is everyone okay? Well, we just simply don't have any time. So please, if you can come back, I hope you will, and we will try to take good care of everyone tonight. So we are adjourned.